Please be seated. We now resume our meeting. Before I hand the floor to the parties, the graphic, could you please report the attendance of the parties and individuals to today's meeting? Sakalbuti, Mr. President, for today's meeting, all parties and individuals to today's meeting are present, except the Council Sun Arun, the National Council for Nunchi, who is absent due to his health. Kirsanpon is present in the holding cell downstairs. Thank you. President, thank you. And to begin our meeting today, I'd like to hand the floor to Judge Cartwright to put some questions to the Acting Director and Deputy Director of the Office of Administration concerning the commencement of case 002/02. Judge, you may proceed.
Thank you. Thank you, President. The Chamber felt it would be useful to make sure that it has a clear understanding of the budget and other technical information given to it tomorrow. So on behalf of the President, I would like to summarise our understanding of just some parts of the very extensive discussion that we had yesterday. And this relates to the provision of resources for a second panel and its staff, or just for the staff to additional staff to support the existing trial chamber. So I will summarise and just check that we have a clear understanding. First of all, the costs of funding a second panel and its staff, or alternatively additional staff for the current chamber, would be paid out of a contingency fund which would cover the costs only for the international side. Is that correct?
Okay, so I will, good morning, judges, everyone. I will answer on the behalf of both of us. So there is a contingency fund on the international budget, which is for any purpose. First come, first serve.
And that includes payment for a new panel of national judges and its staff, potentially?
Potentially, yes. Any unplanned activity falls under the contingency.
Thank you. The contingency fund forms part of the budget that has been put before the principal donors group for approval, but the budget has not yet been approved. Is that correct?
It is correct that the budget is not approved, but the donors stand ready to address any request from the bench on any issue at any time. So a decision on the second panel is not pending the budget process.
The contingency fund is part of the budget process, which will be approved at an unknown future date, but if history is correct, that will be approximately February of next year. Is that correct?
It is correct that the last budget was approved in February.
although the principal donor group stands ready to support a second panel and or its staff, if that is what the President directs, nonetheless it has to have funding, it has to have the money to do that. Am I right in my assumption that it is unlikely that the money, the cash, would be available before February, approximately, of next year?
The money will be made available at the time when the principal donor group make a decision to support, and then the cash used will be drawn upon by the cash available currently.
That is unlikely to be an overnight decision to provide funding, given the complexities of the process of getting together the principal donors group at this time of year, and moreover, the time it would take for it to assess the cost and where the money, the funding, the cash might come from. Is that correct?
The cash issue is from the bank account of the UN, so that's not an issue. The decision to support such a request, the sooner we get the request across, the sooner they can make a decision. Obviously, if we wait to the 24th of December, they will go on Christmas holidays.
And a request potentially could include funding for both the international and the national sides of the court, both the judges and the staff. Is that correct? And would the principal donors group instantly make a decision to fund that and provide the cash, provided a decision reaches them in a timely manner?
The principal donor group addresses both sides of the court, so it's one entity for both sides. I do not know what the final decision of the principal donor group will be, and I cannot speculate in that.
Until the money is approved, hiring of staff or indeed appointment of a second panel cannot start. Is that correct?
Yes, that is correct. We will need an endorsement from the principal donor group.
So if the decision does not come until the new year, say even as early as January, if it's just dependent on the principal donor group, hiring cannot start until after the funds are at least promised, if not in the bank. Is that correct?
The recruitment process can start as of decision making.
But the deployment of staff and or a second panel of judges cannot occur until the money is in place. Is that correct?
No, that would not be the case. The deployment of the individuals talked about is from the date of the decision.
So, in summary, as soon as the President makes the decision, a second panel can be deployed, if that is his decision, and its staff can be deployed, if that is his decision.
The decision I'm talking about, or I refer to, is the endorsement of the donor group.
And are you telling me that the donor group would make this its earliest priority following the Christmas break in New York?
What they have committed to is to address a request with the highest priority.
You said yesterday that the time needed for hiring staff would take some weeks. it's the experience of this chamber and possibly other chambers as well that some weeks is usually in the vicinity of at least 2 months. Do you accept that?
Yes, I have no problem accepting that.
And in the case of officials such as the judges of the chamber, it could take a great deal longer than that because they would have to make themselves available. Is that correct?
That will be correct for those who are coming from outside the ECCC. If the judges are within ECCC, they are, of course, readily available.
And then the Supreme Council of the Magistracy, if these were judges that had not already been approved by it, would need to make a decision on that. And that would take a little time as well.
Yes, that is correct.
So let's use the example of the endorsement of the deputy prosecutor on the international side. How long did it take for the Supreme Council of the Magistracy to approve his appointment, which was announced yesterday?
Acting Director, Your Honor, to my recollection, as I said, it should take less than 1 month.
Was that the time it took in that instance, or is that your estimate of how long the Supreme Council might take in the future?
Acting Director, through our past experience, the 1 month estimation is the quite highest time period. Usually it will take between 3 weeks to 4 weeks.
Now, I only want to touch very briefly on the subvention process. Am I correct in my summary that currently the subvention process, if approved by the General Assembly of the United Nations, will cover funding for 2014 for the international side, potentially the national side, excluding the judges of the national side, unless the Fifth Committee agrees to the proposed amendment, which would include the national judges?
Subject to conditions imposed by the Fifth Committee, yes, you are correct.
And the subvention process is one, is it not, that requires the agreement, or at least the failure to object, by every member of the General Assembly. Is that right?
Yes, and all member states are represented in the Fifth Committee.
So the decision does not have to wait until the next convocation of the General Assembly, which would be late next year.
That is correct. The decision may even happen in December.
President, Judge Lavange, you may proceed.
Merci, Monsieur le Président.
Thank you, Mr. President, and good morning to everybody. A few follow-up questions, if I may. So we have understood from what we were told this morning that the principal donor group is interested in the idea of a second panel of judges, and the group is ready to examine the request in a relatively expeditious manner. But can you tell us what information exactly has been provided to the principal donor group and who has been providing the information to them, on the understanding that hitherto there has not yet been any kind of estimate made in terms of figures?
On the terminology, the principal donor group is not interested in a second panel. They are aware of the public debate, which includes a second panel, typical the Supreme Court decision, discussing it. I have brought to their attention that debate is ongoing, and I have asked them to be available for decision-making if need be. And they have offered to be available on priority base. On your question from yesterday, and you brought it up that no costing has been done, that is correct. But I did costing after we met yesterday, so if it is of interest, I can present the amounts today. Okay. So the current trial chamber, as it is currently staffed, is budgeted for 1.1 million for the staff and 640,000 for the judges on the international side. And the respective amount for the national side is 15,000. Sorry, this is monthly, so I have to multiply it. So that's annual for the UN. Unfortunately, my note here only have the monthly for the national, so it's not equal. That's 1.8 million for an annual international side of trial chamber. The similar amount for the national side is 37,000 or 38,000 for the monthly cost. But then you have to multiply it with 12 for those who are quick in mathematics. Now, the overlap will then be 6 months. I understand that the verdict in the first phase is scheduled for the second quarter of next year. So a potential overlap of staffing will be maximum 6 months, from January through June. And then you could, do a calculation of that. That will be on the international side. If there is both judges and staff, equal staffing, roughly $1 million, 900,000. And for the national side, for the 6 months, it will be 225,000. Thank you.
Yes. Thank you for those figures. So the principal donor groups has had its attention to this issue been drawn to it by yourself. Now, yesterday at our meeting, a certain amount of information was exchanged, and I suppose that when the idea of a second panel of judges was presented, it was both with the idea that it would be a gain in terms of speed for the trial, and that it would also be beneficial in terms of the overall expenditure of the court. Now, there is a certain amount of information which would suggest that these ideas are at least worthy of discussion. And yesterday the international prosecutor told us that if a new panel of judges was established, that would, of course, imply some significant revision of the timelines of the trial. But since you provided this information, is it your intention after this TMM to refer additional information to the main principal donors group in New York? Is there going to be a new meeting between them in the near future? How are they going to be informed of what we are saying to each other here today? Thank you.
Well, I have understood the prosecution's proposal is that the current panel continues with the sitting judges, and if need be, additional staff may be provided. That's how I understood the prosecutors yesterday. On the second part of your question, I have a dialogue with the principal donor group in New York on a routine basis. The conduit is through my secretariat in New York, which is DESA, the Department for Economical and Social Affairs, and the special experts, which is Mr. David Sheffer. So that's the conduit, that's the channel. But I have a routine dialogue with the donors on the ongoing operations of the court.
Voilà, donc en fait,
So it would be through David Sheffer that the principal donors would be informed about the potential difficulties attached to the establishment of a second panel. At the same time, the principal donor group is asking you to cut the budget submitted by an amount of some $2 million. Is that correct?
David Sheffer is one of many sources for the principal donor group to seek advice from. I am not, he doesn't monopolize my communication channel with the principal donor group. I also communicate with them through the Secretariat in New York, which is, as I said, the Department for Social and Economical Affairs. The second panel discussion is not linked to the budget process. As I said yesterday, the budget do not contain any reference to a second panel. So that is an ongoing separate matter, and they are asking us to make the court proceedings as cost effective as possible. That has been a standing request from the donors since 2006. So that is a normal debate. The second panel is not debated per se with the donor group because no request has been put in front of them. As I said, they have been made aware of the discussion which is happening within the court, and to make them informed so that they are ready to make a swift decision if asked. Thank you.
yeah.
Thank you. I assume that for the principal donors, the question of costs is going to be central to their concerns. Now, we're talking here, of course, about the budget, but I would like, if we can, to come back to this issue of the subvention. You have talked about collecting funds and saying that the approach is slightly different here. If this proposal for a subvention is adopted, then expenditure would directly be drawn on the United Nations budget. For this subvention to be adopted, is it true to say that all of the United Nations member states have to approve? In other words, is unanimity a requirement from all of the member states of the United Nations in the General Assembly for the subvention proposal to actually be accepted? Thank you.
On the first half, that cost is a concern for the principal donor group. Yes, it is. But the overarching interest of the donors is an expedited process. So they are standing ready to support any initiative to expedite the judicial processes at this court. On the second half, it's majority vote.
Donc il suffit une décision.
I see. So you need a decision by the majority of members of the General Assembly for the subvention proposal to be adopted. Is that correct?
It's within the fifth committee, so we are not, just to make sure that we are not talking about 193 voters. So it's limited to the fifth committee and who sits in the fifth committee, which is the finance committee of the General Assembly. The member states are represented in that smaller entity. And when we have a vote there, the process is over. It's not like one member state can veto 192 others.
And is the decision in the Fifth Committee a majority decision or one that needs unanimity to pass?
I believe it's a majority vote. But now, with this repeated question, you put me on a shaky ground here, so I will again get back to you. But my answer today is majority vote, and I will correct myself if need be.
Merci, Monsieur le Directeur.
Thank you, Deputy Director.
The President, thank you. Now I hand over the floor to the various parties concerning this second item on the agenda in relation to the administrative aspect of trial management in case 002, as well as additional question posed by the international judges to the Director and Deputy Director of the Office of Administration. Now I hand over the floor to the Office of Co-Prosecutor to put the question to the Directors if you have any question for them. You may proceed.
Thank you, Mr. President. Good morning, Your Honors. Ms. Chea Lang is unable to attend today because of other commitments. She did ask me to ask a question of the acting director. So if I may, I first will begin with her question. She indicated to me that based on the budget process, she has already cut 2 staff members for 2014, 2 national staff members, and recently received a request to cut an additional staff member. Her question is that given the potential demands on the Office of Co-Prosecutors next year, that is the appeal of case 0201, we hope the beginning of the trial of case 0202, and we expect requests for submissions on cases 03 and 04. Will there be funds in the national budget, whether line item or in a contingency fund, to fund positions that are necessary to complete our work?
Good morning, judges, and good morning to all parties. In order to ensure consistency as well as efficiency in the operation of the Office of Administration. Certain positions have not been renewed. It is not confined to the Office of Co-Prosecutor, but also to other offices. And we have done this in consultation with the respective offices and section. As for 2013, the budget has already been approved and it has already been implemented. As for the budget for the non-regular staff, we may use this budget for the case-by-case need for 2014. That is done in reflection of the actual need for 2014 and 2015.
Okay. Perhaps to follow up on her question, and also I have my own follow-up to the very first question that Judge Cartwright asked. It was about whether, if additional staff for the trial chamber or judges for the trial chamber are needed, could the International Contingency Fund cover national judges and national staff? And I believe the Deputy Director answered that that could be used. But I'd also ask, is there, to be clear, a contingency budget in the national budget? Is there a contingency budget, perhaps called by another name? I understood you have another name for such a budget, to cover contingencies and potentially to fund national staff for the trial chambers or national judges.
Thank you. Since the first part of your comment was related to me, I sort of threw the answer in its totality. No, the international budget cannot be used for the national side per se. But the donors stand ready to address any request from the court, being either side, and it's the same decision-making body. So in that sense, we are talking with the same people. In the national budget, there is no contingency line, but under the so-called GTA, General Technical Assistance, there is a description of peaks in the work, which may be drawn on, which when peaks are occurring. So it's a foreseen increase in workload at times.
Just to relate that to the specific issue of whether if additional staff are needed to fund the start of case 0202, could this general technical, I've forgotten the name you used, this line item be used to fund this additional staff?
Yes, it can.
Thank you. And then just one additional follow-up to the judge's questions. On the issue of is cash available, should a decision be made and additional staff or additional judges be required? Was my understanding yesterday, please correct me if I'm wrong, this is for the Deputy Director, that there is now, or at least was yesterday, $2.7 million available, and there's an additional, at this point, $4 million in commitments, in firm commitments for funding for the court, which would be available to pay for this staff.
Thank you. Those amounts is related to the international side of the budget, and the balance of 2.7 referred to is the expected balance at the end of the year, and it's correct that pledges have been made for $4 million into next year.
And is it correct this money would be available next year to fund additional staff for the trial chamber if necessary, or if necessary, which is not the prosecution's proposal, additional judges for a new trial chamber?
Yeah, this is cash in the bank account, so that is available for any purpose.
Okay, thank you. I have no further questions, Mr. President, this time. Thank you.
The President, thank you. Now I hand over the floor to the lead co-lawyer for the civil party. If you have any question to the acting director and deputy director of administration, you may proceed now.
Thank you, Mr. President. Good morning, Your Honors. Good morning to everyone in and around the courtroom. I just have a few follow-up questions excuse me, to the acting director as well as the deputy director. First, I want to follow up on the co-prosecutor's question on the commitment to the budget. We heard that there is commitment and there is cash available for the international side. My question relates to the national side. Is there any commitment already available at this point for the upcoming years 2014 and 15 on the national side?
As I have informed the judges and members of the meeting, that for now we have to wait for the approval for the joint budget proposal to be approved by the group of interested states. And once they approve this budget, they will review the need as per our request. And as for now, only the royal government of Cambodia has confirmed that they would commit the same amount of funding to this tribunal. That is the status of confirmation concerning funding for the national side as of now.
Thank you. And given that situation, and you mentioned yesterday also that since 2008 there were problems with cash flow on the national side, do you foresee the same problems of cash flow in the upcoming years as well?
We have to wait and see at this moment. To date, the cash in our bank account is only available for the payment of salary of the national side for this month, for the month of December 2013. That is all.
Thank you. And as I understand, if national staff would have to be hired as support staff for a second panel, as well as national judges, that would come out of the national budget, which means the national side money. Is that correct?
That is correct.
So in that case, would hiring additional national staff aggravate eventual cash flow problems in the upcoming years if this national budget is not yet committed?
Well, we have encountered these turbulences since 2009. The issue of budget is one thing, and the turbulence in the cash flow is another thing. We have encountered difficulty paying staff on regularly, but we have actually paid all the staff, even though we know that it has not been regular, and we have to wait for the approval for the budget. But we, of course, acknowledge that we have encountered some turbulences in the payment. But I don't foresee that that will pose any threat to the recruitment of new staff if need be.
Thank you very much. I have no further questions.
The President. Thank you, Counsel. Now I hand over the floor to the defense teams. We will begin with the defense team for Mr. Nguyen Chia first. If you have any question to pose to the acting director and deputy director of administration, you may proceed.
Good morning, Mr. President. Your Honors, we have no questions.
The President. Thank you. How about the defense team for Mr. Kyu Sampon? Do you have any question to put to the directors?
Good morning, Mr. President. Good morning, Your Honors. Good morning to all parties present. If I may, I do have a question of clarification. Perhaps it's redundant, but I do wish for things to be crystal clear. I would like some follow-up explanations to the comments made by the Deputy Director, in which he stated that the budget for the defense for the next 2 years had been confirmed based on the current setup and composition of the defense teams. Now, is this my correct understanding? Has there been confirmation of the same budget for the defense support section for the upcoming 2 years, which mirrors the last 2 years that we have just covered? Is this correct?
Thank you. Limited to case 2, that is correct.
Je vous remercie. Thank you very much. Therefore, the announcement that was made, according to which some of our teams could be reduced by 2 support staff, that being the position of a consultant on the international side and a case manager, given the explanations that we were provided during this trial management meeting, and based on the work ongoing and the potential work required for an appeal of case 002/2. Well, the risk that some of our teams could be reduced is a risk that can be averted. Is this still the case?
The size of the defense team is not dependent on the budget. That is dependent on the actual work demand. And I believe that DSS is readdressing the need of the current staff, which was present during the hearing and the closing statements, in the period up to verdict, where, as I said, the second phase of case 2 is not planned. So we see this as a downtime. So that's the backdrop of that request. But I also believe that no decision has been made by DSS on this.
And therefore, based on your explanations, the risk that our teams may be reduced to 2 people, reduced to a case manager and an international consultant, based on your assessment of what our operations and work is comprised of. Is this a correct understanding?
Yes, that is correct. It's not financially driven.
Là, c'est une observation.
I wish to make a general comment to the trial chamber. You understand and can appreciate that these discussions are extremely significant, and given what has been announced by the Office of Administration, the possibility to prepare for the upcoming weeks are, in my view, extremely arduous. And this is not for lack of will on the part of defense teams, but because of the restrictions that we face, and that are simply beyond our control. This is a comment that I wish to put on the record, and that I sought to add as an item on the agenda. But if we are to make the appropriate filings and submissions, and if we are to delve into the issues and the legal issues of case 2/2, as well as the appeal, since the matter of the appeal is not confined to the judgment or the verdict that you will be issuing, but also the fact that we will have to respond to that decision. And this is an extremely important factor that has not been taken on board or taken into consideration neither by this tribunal nor by external parties. The defense teams will be encountering problems on top of the budgetary problems before those budgetary issues are resolved. And I wish to state that for the record during this public hearing. Thank you.
Well,
The President. Thank you. The International Co-Prosecutor, you may proceed.
thank you. Your Honor, I just wanted to provide some information that my office found that may assist the question that Judge Laverne asked about the voting procedures for the committees of the UN, the Fifth Committee. We found on the internet that in the UN General Assembly Rules of Procedures for Committees, Rule 125, paren 85, states that decisions of committee shall be made by a majority of the members present and voting. Thank you.
The President. Thank you for the information. Now we move to item 3. Item 3 concerning the scope of case 002/02 and future trial segments. The third item on the agenda concerns the scope of case 02/02. The Supreme Court chamber has suggested that under certain preconditions, it might be possible under the ECCC legal framework for the co-prosecutors to withdraw charges. This would appear to introduce an additional factor in the determination of the scope of any second trial segment. This also raises a number of legal questions that need to be discussed and determined. This could be a matter either for this chamber, or rather, and this, or to be were it to be appointed for the second panel. The current schedule does not provide sufficient time to debate this complex legal issue at the present meeting. However, an additional discussion of the scope of case 02/02, including a presentation of the parties' preliminary views on the matter, would benefit the ultimate determination of this issue. In order to commence this process and to deal expeditiously with the issue, the trial chamber, therefore, will now invite submission from the parties on which charges you consider ought to be included in case 002/02. In its previous decision on this matter, the Supreme Court chamber had already given some indications of what charges case 002/02 should include at minimum, such as charges related to S21, a work site, a cooperative, and genocide. On the basis of this, could the parties please address which charges and/or crime size you consider ought to be included in case 002/02? On the basis of these proposals, can you please provide an estimate of the length of ensuring proceedings? of the ensuing proceeding, rather. Now I provide the floor to the Office of Co-Prosecutor before other parties to the proceeding. You may proceed.
Thank you, Mr. President. I will ask Mr. Lysek to speak on behalf of the co-prosecutors in detail about our trial plan. I would just introduce it by saying the following. We have proposed a plan, which we've submitted in writing, to cover all of the requirements of the Supreme Court and to go beyond that somewhat. Our proposal is to try, in case 0202, all of the remaining legal charges. In other words, to cover all of the genocide, all of the counts of various crimes against humanity and war crimes, to cover the crimes against each targeted group, to cover the gender crimes, the forced marriage, and the rapes, all in this trial. And the plan, the witnesses we suggested, we estimate would take 96 court days to cover all of these. Now, as Mr. Lysek will explain, our suggestion is, in order to expedite these proceedings, that all of the charges will not include every crime site that's covered by the mentioned in the closing order. It would include all of the charges that are in the disposition. So we believe that this will certainly satisfy the Supreme Court requirements. More importantly, it will allow a very efficient trial to be done in a very reasonable period of time to cover the heart of what this tribunal was set up for, to cover the genocide charges, the security centers, the tortures, the forced marriages, and the rapes. And we believe we can do this in a very reasonable period of time. I'd ask Mr. Lysek to address the specifics.
The President, thank you. Mr. Lysek, you may now proceed.
Thank you, Mr. President. Good morning, Your Honors. We did submit our proposal in writing because it is detailed, and we believe that would facilitate the Chambers and the other parties' review. So I will be relatively brief now, respond to any questions you have, and of course respond to any comments or issues raised by the other parties. Let me simply say that a large part of our proposal was mandated by the decision that was released by the Supreme Court Chamber in November. The Supreme Court Chamber ordered two things. One, that evidentiary hearings in the second trial commence as soon as possible. And second, that the second trial comprise, I quote, at minimum, the charges related to S-21, a worksite, a cooperative, and genocide. So in our written proposal, much of it is mandated by what the Supreme Court has ordered. Therefore, we have included S-21. We have included genocide of the Cham and the Vietnamese. They have ordered that a cooperative be included. There is only one cooperative crime site in the closing order. That is the Tram Kok District Cooperatives. And we have proposed as a work site, as our first choice, the 1st January Dam, a very large work site that was representative of the building of water projects, dams, canals, which was a significant part of the forced labor that occurred during the period of democratic Kampuchea. In addition, we've proposed a few additional sites on top of that. And we made that in view of the second question that arises from the Supreme Court's decision and is indicated in your memorandum, which is, will there be should we plan for a third trial? Our answer to that is that we should not. That we should include in the second trial all the remaining legal charges and representative crime sites so that the second trial can be the final trial of these two accused. And those are the two foundations, if you will, to the proposal that we've made. And because of that, we have proposed a couple of additional security centers and one additional work site, which would ensure that the included crime sites that are tried between cases 1 and cases 2, or I should say case 002/01 and 02, between those two trials, we would have covered crime sites from throughout the country. We would have covered all of the legal charges in the indictment. And we would have, to summarize, had 2 of the 3 forced movements would have been tried. 3 of the 6 work sites or cooperatives would have been covered in the 2 trials. 5 of the 14 security centers or execution sites would have been tried. The 4 targeted groups that are part of the indictment, all of that would have been prosecuted and tried, as well as forced marriage. So that was the thinking, if you will, that went behind our proposal. I'm happy to answer any questions you may have at this time, and also, of course, to respond to any issues raised by the defense.
President Judge Lavange, you may proceed. Thank you.
Well, there are a certain number of issues that come up here, and among these problems, there's a question of duration of the trial, and we have to see what necessary phases will have to be got through before we start the substantive hearings, what is going to have to be done to resolve the issues relating to those different stages. Then we have a problem perhaps of terminology or of wording, because when I hear you telling us that you are proposing to review in the next trial all of the charges contained in the indictment, what I understand is that is not all of the crimes, because in French charges, chef d'accusation can correspond to each specific crime. But when you say each one of the charges, it is presumably the different categories of specific crimes. Is that what I should understand? Thank you. I have an initial comment about the timelines involved here. We'll come back to substantive contents in a minute, but can you start by telling us how you did your calculations for the time that's going to be necessary for each one of the witnesses, experts, or civil parties that you are planning to summon? Because what did strike me on an initial reading of the document that you submitted was that most of the witnesses that you are proposing are to be heard for half a day or 3/4 of a day. Is this the time that is necessary for you, the prosecution, to question these witnesses? Or are you giving us an indication of the time necessary for all of the parties to ask their questions? I'm a little bit surprised. It seems to me that the number of witnesses that the Chamber has heard, once all of the parties have put their questions, the number of witnesses that it was able to hear in less than 1 day was pretty few. For most of them, it was at least 1 day for hearing a witness or a civil party. So can you just enlighten me on all of that? Are we talking about the time for the prosecution or for all of the parties to put their questions? Thank you.
Thank you, Judge Laverne. Let me start just in relation to your first comment. Let me confirm that your observation is correct. When we say that all charges would be tried, we are talking about the legal charges, genocide, the various crimes against humanity, and the various specific breaches of the Geneva Convention. So we are talking about the legal charges, and we are proposing that the crime sites be reduced. In response to your question about the witness proposal, the times that we propose are the total times. And I would note that what we have tried to do here is distinguish witnesses. Where we are dealing with a witness who we view as a witness who would testify to a fairly discrete event, a certain crime, as opposed to a witness who will cover broader issues related to possibly linkage, or someone who is a cadre who is involved in more of the operation of, say, a security center. We have put more time for the latter type of witnesses. But for witnesses who are we view as providing a fairly limited range of testimony, we are proposing that we endeavor to get through the crime-based witnesses fairly quickly. And I understand your comment about a period of time that was required in the first trial. I would remind the Chamber that we had a week or 2 weeks where we heard from a number of civil parties who came here, related their experiences of what had happened to them in the forced transfer, as well as their suffering. And we heard 4 people a day during that period. So those civil parties were heard in a quarter day each. We're not suggesting a quarter day, but we are suggesting that for many of these witnesses who have fairly limited facts that are pertinent to this and who have already provided written statements as well, that we endeavor to get through those witnesses quickly. So that is the basis. And obviously, other parties may have different views. A defense or another party may say, we view this person as particularly important, half a day will just not suffice. That's a process we'll have to go through. But that was the thinking behind our witness proposal. It was an attempt to distinguish witnesses who have more complex issues to deal with from those who have a fairly limited range of facts to testify to.
First question. To draw up these estimates of the time needed, did you talk to the other parties, with the civil parties or the defense?
Your Honor, we had some consultations with the civil parties in general about the plan, more about the proposed crime sites, not so much in terms of going through witness by witness and agreeing on time proposals. So the answer to your question is we did have some discussions about the scope of the trial, not about time requirements for individual witnesses.
Coming back to the experience that we may already have had with questioning civil parties or witnesses, it's true that we heard some civil parties come to testify here within limited spaces of time, and that several of them were able to testify within one single day. But they were called to talk about their suffering rather than to bring substantive evidence. Second, you draw a distinction between witnesses whose testimony might be more general in nature concerning the structures or the responsibilities of the accused, and those witnesses who are going to come and talk about specific crime sites or crimes. Let's take Tuolpochrei as an example. Now, it seems to me that this is a specific site. Originally, I think you were planning that we should only hear 2 witnesses. Now, this turned out to be not quite enough, and other witnesses were called. So, for witnesses on specific sites, if my memory serves me well, I think we spent a good deal more than 1 day per witness. So I'd like to know if your estimate here is really based on past experience, or if you are in fact thinking about radically changing the way we have acted up to now, because I don't quite see how things all fit together otherwise.
Thank you, Judge Laverne. No, we're not suggesting any radical shift. And I think if you look back at the witnesses who appeared related to the forced movement, you will find that many of the people who came to this court were in and off the stand in less than a day. Not all of them, but many of them. We were also, for most of the trial, you will remember, dealing with 3 defense teams and not 2. That's not a major change in how things will operate, but it will affect the timing somewhat. But this is a proposal, Judge Laverne. If other parties think, or the Chamber thinks, it's not sufficient when it reviews these witness statements and it looks at what these witnesses have to say on these issues, people can propose additional time. This is our proposal. We've done it by reviewing the witness statements, assessing what we think this person, the important factual evidence that each of these people would provide to the court, and given you an estimate of, for sure, the minimal time that will be needed to hear them.
Yeah.
There was another point that struck me when I was reading your submissions, and that's the comparison that might be made between the trial that has just finished, 002/1, lasted for 220 days of hearings, and after those 220 days, we had heard 90 individuals in the courtroom. So when you say 96 days, can you tell us if you have any idea of the total duration of hearing days that you would need for the second trial?
Well, just to clarify, the 96 days is the time, the total time when you add up the suggested time for the witnesses we have proposed. So the 96 days merely represents our proposal as to how much time would be required for these witnesses. Obviously, the civil parties and the defense would propose additional witnesses. The chamber may have additional people it wishes to hear. So in terms of the comparison to the first trial, I'm glad you asked that. There is a difference, I think, between the division of witnesses or a relative allocation percentage of what I would call the complex or linkage witnesses that we had to hear in the first trial and the number we would have to hear in the second trial. The first trial, you will remember by your order, was intended to provide the foundation for further trials. And much of the time in the first trial was addressed to some of the more complex witnesses as to how the regime operated, how communications operated, what were the roles of the accused, what did the various organizations in democratic Kampuchea do. Those are complex witnesses, and they required considerable time. For this trial, there are much fewer witnesses of that nature that need to be heard, because we have heard most of them already in the first trial. And that is a fundamental basis of our proposal, is that we would not repeat evidence that was already heard in the first trial, that testimony, those documents would become part of the record. So because of that, there are a much smaller body of what I would call the complex linkage witnesses who will need to be heard in the second trial. And it will be much more focused on shorter crime-based witnesses. And that is why I think when you compare the number of witnesses and number of trial days required, I expect you will find that the second trial, we will hear more witnesses in a shorter period of time. So I hope that answers your question.
During the last trial, we devoted quite a few hearing days to discussion on documents. And there were other problems that arose, procedural problems, and I think we will come to the issues of the different phases we have to go through before we reach substantive discussions. But do you have an estimate of the total duration of substantive hearing days that will be needed before we complete the trial?
The estimate that we provided, Your Honors, was that the trial, in terms of evidentiary proceedings, would require between 12 and 18 months. There is uncertainty here because we don't know how many witnesses will be requested by the defense, how many witnesses or civil parties will be proposed by the lead co-lawyers. So we've provided an estimate of the time that these proceedings could be completed, based on looking at the 96 days that we've estimated, and taking into account that there will be additional time needed for other witnesses, civil parties, and some additional time for document hearings. We do make the point in our filing, Your Honor, that there will be less time needed for document hearings, again, if our proposal is accepted, that we start from the point that what was admitted in the first trial is deemed admitted for purposes of the second trial. Because the bulk of the documents that were proposed by us for all of case 002 have already been admitted. There are remaining documents relating to S21, relating to Tramcock District, but again, the majority of the documents that we had proposed for all of case 002 for both of those locations have already been admitted. The remaining documents are of the exact same type of nature as documents that have already determined to be admissible. So, in short, what I'm saying is, yes, we will require time for document hearings. Our expectation is that it will be less time than what was needed in the first trial, because we have already dealt with many of the documents.
The question about the time that's needed for review or presentation of documents, like the question about the time needed for hearing witnesses, is going to vary in terms of the composition of the panel of judges that will be on the bench for the next trial. Now, if we have a new panel of judges, from what I understood yesterday, then in reality there's going to have to be some very serious revision of the necessary duration. Have you thought about this? Have you done any calculations? Option 1, we keep the same judges. Option 2, there's a new panel. Have you been able to make any preliminary estimates about the duration on the basis of that problem?
We haven't done calculations of the scenario of how long the trial would take with a second panel, but we have thought about the issue, and that was very much paramount in the position we took in our filing, that it would be far more efficient and more expeditious to the extent that we use the same panel or judges, or as many of the judges who are already familiar with the proceedings, not just the evidence, but the procedure and proceedings is what gone before. So, no question, Judge Laverne, in our view, the trial will take significantly longer if we have an entirely new panel of judges.
I have other questions to put to the prosecution about the different phases that are going to be involved, according to their estimates, before we actually reach the evidentiary hearings. But this may not be the moment. Perhaps I should, Mr. President, give the parties a chance to express some general views about the duration of the trial and the other issues connected with witnesses to be called. So perhaps I will cede the floor at this stage, Mr. President.
Thank you, Judge. And Judge Cartwright, please proceed.
Yes, thank you, President. It's the job of the prosecutors to be optimistic about the speed of the trial in all courts, not just this one. And I want to acknowledge that optimism. Yesterday, however, the international co-prosecutor indicated that maybe 2 to 3 years was a more realistic period for the duration, the entire duration of the trial. So let's be clear about that. In your proposal, just the prosecutors estimate that with 96 witnesses and a day each, it would be 96 trial days. Obviously, in coming to your calculation that a trial itself would last 12 to 18 months, you allowed some time for the defence, lead co-lawyers, And did you allow for the 26 national holidays next year, for example?
Your Honor, we did. We recognize that there will be holidays, there will be breaks. And just to make something clear, as the international co-prosecutor indicated yesterday, when he talked about 2 to 3 years, 2 years he was talking about as from the time from now until a judgment would be reached. 3 years recognizes what I think everybody here understands. There is tremendous uncertainty. Yes, our proposal is based on the assumption that things proceed expeditiously. If we lose several months of hearing times, as happened before, then it's not going to be completed in that time frame. So we do acknowledge that, Your Honor.
So you've taken into account the possibility of ill health of the accused or any other pivotal parties to the proceedings delaying matters. But I looked back in the course of reviewing the prosecutor's list of witness, and I need to emphasize that because in the trial, the evidence of which has just concluded, approximately 50% of the additional witnesses, experts, civil parties came from other parties to the proceedings. So potentially we are looking at a doubling of that number, maybe, maybe not. Do you agree with that very rough assessment?
I think my review of the numbers is a little different than yours. I think because the prosecution bears the burden of proof, if you look at the overall number of witnesses that were heard that were on our witness list, I think it is higher than that. And that's not surprising because we have the burden of proof. With each of these crime sites, we have gone through and identified what I think almost everyone would agree are the most important witnesses. So I'm not saying that there won't be a significant number of additional witnesses or civil parties who will have to be heard. Whether it will be twice that much is something that remains to be seen and is also largely within the decision of the judges who will hear this case. They will ultimately look at the other our witness proposals and the others and decide what is necessary. But I certainly do not disagree that there will be significant additional time to what we have proposed in our 96 days.
Well, I was simply basing my 50% comment on a paragraph in your submission which said, ultimately the Chamber heard 92 individuals, including 20 proposed by Nguyen Chia and 23 by Kyo Sampon, and that is in relation to the trial, the evidence of which has just been concluded. Now, that is less than 50% of the 92, but that was the approximation that I was working on. But I want to go back to case 001, which was confined only to matters related to S21, Chung Ek, and Presor. The evidence in that trial took just less than 6 months, just for those parts of the evidence. Now, let's assume we're quicker at it this time, fewer witnesses. It still has to be reheard, all of that evidence, does it not?
Let me say two things. First of all, in regards to the numbers of Nguyen Chia and Kyu Sampan witnesses that you quoted, those were not witnesses proposed exclusively by them. Many of them, in fact, a large percentage of them were witnesses that were proposed by both the co-prosecutors. So I think if you look at the number of witnesses who were not proposed on our list at all, it is a much smaller percentage than 50%. In regards to S21, I think it's hard to compare to the first trial. And keep in mind that a significant amount of time in that trial was the testimony of Duik. We do not need to repeat all of that evidence. Duik testified in the first trial in Case 2. We've proposed that he reappear and testify again here. But we do not need to have, and I don't have the number at my disposal, but he spent a significant number of days giving evidence in that Case 1 trial. We do not need to repeat that. There are some issues that I think are different. The focus of this trial is more on the accused's role. How did the people who ended up at S21 get there? Who was responsible for that decision? Less of a focus on the internal operations within the prison. So I think that the comparisons are somewhat difficult. And I would remind Your Honors, too, that when we initially proposed S21 be added, Your Honors inquired of us whether it would be possible to hear S21 with only Duik. So I do think that these crime sites can be tried fairly expeditiously. We understand other people will have proposals, and so it will take longer than the 96 days we're proposing.
Even so, in the case of Gengek Yu, you've proposed approximately 5 days for his testimony. That's 25 hours. So he will still be a significant witness, and the 5 days devoted to him means far fewer days to the other witnesses. But I think you have been quite clear and helpful this morning, and for my part, obviously the parties will have their own views, but you acknowledge that this is the proposal only from the prosecutors. It is unknown what additional time, numbers of witnesses will be needed to meet the requirements of the lead co-lawyers and the defence. And you are not suggesting that a mere 96 days will be required. It is potentially significantly more than that. And of course, all of this depends on this proceeding before the existing panel and not a second panel. By your nodding, you agree with my summary, Mr. Lysak.
I do, Your Honor. I'm fully in agreement with those observations.
Thank you very much.
President, thank you. The International Deputy Prosecutor, the time is now appropriate for a short break. We will take a 20-minute break and return at 10 to 11 to continue our meeting.
សូមអញ្ជើញក្រោកឈរ